Diane Bercherer
It's Becker, Your Honor. It's German. It's German spelling.
versus State of Nevada.
Okay, Mr. Miller, you here for this one?
Yes, Judge.
Mr. Nelson?
Yes, Your Honor. Bruce Nelson appearing on behalf of the state of Nevada.
In this case, I have to say, it's the first I've seen it that I could recall.
Yes, Judge.
It's
I
a-
thought you'd enjoy this one.
Okay, it's an issue having to do with the idea of authorities here in Clark County setting up a DUI checkpoint. It also, of course, involves another issue, and that is whether the appellant consented to a breath test under the circumstances. You know, I've looked at this because it was a matter of first impression that I can recall. And if you'd have asked me before I looked at this, was there a law or statute that talked about administrative roadblocks? I'd have said, I don't know. I don't know if there was one. Turns out there is, NRS 484B.570, which talks about administrative roadblocks, their requirements, and what have you. And so that's all here. I can reference it in the argument if anybody wants to talk about it further. You probably do. And then, Mr. Mueller, I know you have this consent or non-consent issue you want to talk about. So why don't I just go ahead and turn it over to you, since it's your appeal, and we'll go from there.
Thank you, Your Honor. When I'm like a kid on Christmas morning, I want to go right to the interesting toy and rip it open and start talking about the constitutional issue. But I do know by law and custom and practice, we need to start on the factual basis and then work up to the constitutional issue. So I will.
Yeah, I don't know. You can do that if you want. I mean, I've seen some Tarantino movies, so if you want to give me the ending, go ahead.
All right, well, Your Honor, here's the thing. And this experience that we've had with the Howard decision and the Byers decision has taught me to do something, and it kind of was a little cold bucket to me. And it occurred to me that a lot of the canards that I've been taught as a young district attorney might not be quite as rock solid as I thought they were. And I've gone back now in my law practice where time permits to go back and start reading source documents and start rereading cases and discerning them with maybe a more mature insight than I had 20 or 30 years ago.
Mm-hmm.
Now, what is very concerning to me is the Nevada State Constitution, which is omnipresent and should, of course, be the law that first we refer to, not the federal Constitution. Article 18, Section 1 says that no search shall occur or warrant will issue without a finding of probable cause by an impartial magistrate. Now, this is a particularly offensive case because the officer here, Hobson and Lang, both testified. They actually testified in this case that there's no probable cause for this stop. They literally walked into the street, grabbed the car at random to see if they were committing a crime. That's what happened here, in direct violation of the Nevada Constitution. Now, that's an illegal search and seizure, and they have no authority, none, to get to what happened next. Now, that's the key issue here. What does this provision of the Nevada Constitution mean? Because if it, Lord knows they've lectured me enough. Terms in the Constitution mean their plain language of their meaning. Now, plain language of this statute means that no search or seizure shall occur. And they didn't just grab him.
Hold on a second. There's a lot of talk in the back of the courtroom. Dominique, can you let people know that we don't want that? Just I can hear it. It's just something that is going to interrupt the proceedings. Okay, so let's try to keep our voices down back there. Go ahead, Mr. Miller.
So so right off the bat, this case starts off with this assumption. It's an illegal search and seizure. They walk into traffic. Their only purpose for doing that is to see that the people unknown and unseeable by them, to do a random check to occur to see if they are doing something wrong.
Right. Is it that you don't think that the statutory scheme and the law associated with checkpoints has been followed. Is that it, or is it that you,
Well,
I'm just asking you, is it that you think that even in light of the statutory scheme, that it's just an unconstitutional provision? I'm trying to figure that out.
Number one, it's unconstitutional. Number two, they didn't comply, even if they could arguably.
So you're saying that NRS 484B.570 is unconstitutional?
It's unconstitutional as applied, and they didn't even apply it properly. But those are factual issues that I'll get to. The come-out role here, to use the Las Vegas term, is an illegal search and seizure. And what they did, make no mistake, is they walk into traffic, point at a car, and get them out of the car to see if they're doing anything wrong.
All right, I'm going to have to object at this point, Your Honor. That is a complete mischaracterization of the evidence in this case. A checkpoint was set up that the defendant entered. The police did not walk out into traffic and randomly start pulling over cars. And I would invite Mr. Mueller to show where in the transcript that is specified.
Okay. If you give me a minute, I will show you exactly what I'm talking about. Now, there's no probable cause, and Hobson admits it. He says it under oath, no probable cause for this stop. So they get Miss Becker out of the car.
That's the nature of a checkpoint, though, it seems to me. If you have and I know you think the statute's unconstitutional, but if you have a DUI checkpoint, I mean, everybody driving into the thing is subjected to a
Yes.
health, welfare, public safety check is what it really is. That's the reason they do these things.
Well, no, there's the practical problem with this. And once again, I went back and I've started rereading these source cases. In states where driver's license and registration and proof of insurance are civil infractions, then the government has the ability to check for you compliance. Like when you stop on a boat and they ask for your fire extinguisher. That's a civil regulatory scheme. The Nevada, as the U.S. Supreme Court, it says, well, when you're looking for driver's license, registration, and proof of insurance to comply with the civil regulatory scheme, and you discover somebody's drunk driving, well, then you haven't done anything improper. Okay, so where the scheme, there was a case out of Indiana where the scheme says where you had a statute saying, we're gonna stop people at random to see if they're drunk driving, the Supreme Court struck that down. Now, here's the practical problem here. Our Constitution makes it abundantly clear. You don't stop people at random without a warrant from a magistrate, period. That's it. Now, assuming arguendo that this checkpoint statute scheme if the statute is legal, then it wasn't even followed. Now, I'm going to write down the points here. The officers could not, and so they don't have the paperwork to show that the test was done. Nobody brought, or the checklist wasn't there. They didn't bring in the recording. They don't have any photographs of this checkpoint. None of the regulatory scheme that was done. When you see the scheme, they're supposed to be assigned 500 feet away. They're supposed to be this, they're supposed to be that. And we asked them, well, did you do it? No. Well, was it there? Well, I think so. So if they're going to rely on a lack of probable cause in a criminal statute, then they have to come with their A game. There's supposed to be a showing by the guy who set the thing up, the sergeant who put up the checkpoint, the checklists that all went out there. None of that's in the record. Now,
Would you be, I mean, I don't know if you wanna do it this way, but I mean, I thought you might.
sure.
And I understand where you're at. You're saying, look, obviously you think this is an unconstitutional provision, but then you make the argument in the alternative, which is a wonderful way to do it, and that's permissible and fine. But since the statute is so specific, it just seemed to me that the better way to do this would be to show me where the government or the prosecution failed to establish any evidence in the record that complies with the statutory scheme. In other words, the whole idea of the 100 yards, well, you can read the statute. I mean, it's in both of your briefs.
Yes, sir.
It has a lot of specific provisions. And I think it would be a good argument if you could show me that some parts or any part of the statute wasn't followed.
Certainly, Judge, is actually in the transcript, and I'm citing from Mr. Morey's brief, page 9, where Hobson, who was the first officer to, Beaumont Hobson's first officer to testify, officer was asked about how the checkpoint was announced to the public, and the officer testified in the case he wasn't sure. He was shown a document, testified, well, we did assist in setting up a lot of that, but could not testify to the procedures from memory. He claimed they were true, but he couldn't remember. Now, the interesting thing, if you want to actually do it from, as you're advocating, and I'll follow your lead here, is this record is actually silent as to what her test results were. If you go through it, it doesn't even say that she tested above the legal limit anywhere in here. That was the interesting thing, as I went back and I reread this and looked at it. There's not even a record here is that she tested above the legal limit. Now,
Okay.
all right, so if you go through the record, now, the other practical problem, and the very practical problem, is to say for a moment, you don't want to touch the constitutional issue, you don't want to touch the checkpoint issue. They didn't establish who did the breath test. Hobson's thought Lang did it, Lang thought Hobson did it. Neither one of them could be, the breath observation period is an essential element of the test, as I'm sure you know by now, that you gotta do the breath test, and you gotta do 15-minute close visual contact. They testified, and I believe it was Lang, and I don't want to misspeak, my recollection it was Lang, he said, well, we had 15 other people stopped at this checkpoint. Well, sir, that's 15 people at 15 minutes each. How did you do the breath observation period? That's over 4.5, I mean, you can get up, that's 4.5 hours worth of breath observation period that needs to be done, for which there was no satisfactory answer. Well, the reason there wasn't a satisfactory answer, and the reason neither Lang nor Hobson could tell who did the breath test, was because it wasn't done, not properly. Now, that's a factual issue that's in the record here.
Okay. What I want to do is, I mean, if you want, I'll give you time at the end.
Okay, certainly,
But what I want to do, because it's just of interest to me. Now, Mr. Nelson, I don't think it would be typical or required for an appellate court to look at you and say, show me where the evidence in the transcript is complying with every part of the statute. But I am interested in it. I mean, because I just want to tell you, I don't know if you agree or disagree, but in my view, if the Nevada legislature takes time to promulgate a statute that lays out legal requirements to have an administrative roadblock, well, it seems to me that the government, the state in this situation, has to comply with it, or there's an argument that what you have is an invalid roadblock. That's just my thought. Go ahead.
Well, I'm sorry, Your Honor, with your permission, I'm going to back up a little bit.
Okay.
Does due process apply to the state of Nevada? Mr. Mueller failed to properly raise this in the court below. He was mandated by statute, talking about statutes, any motion to suppress evidence, quote, must be made before trial, close quote. Doesn't say may or can, it says must. He intentionally violated that rule by failing to file any motion to suppress prior to trial. Now, he claims that, oh, I wasn't aware of this until trial. He had discovery. He knew this was a checkpoint case. He waived this issue by intentionally failing to follow the proper rules. And the reason he did that was because if he had filed a motion, the state would have cited stits and so on in response, and he could not have attempted to mislead the court. The court rightly found that he did not properly bring this before the court and prohibited him from raising the issue. Now he's raising it for the first time on appeal. He is prohibited, respectfully, from doing that.
Because it's a motion to suppress.
It's a motion to suppress. If he's attacking he's arguing that all the evidence has to be suppressed because the checkpoint is unconstitutional, he must bring that up before trial. He intentionally did not do that. He just told you a minute ago, oh, well, there's nothing in the transcript about who gave the test. Well, let's look on page 52. Line 14, Officer Lang testifying. And ultimately, did you administer a breath test to the defendant? Answer, yes, I did. So he's again misstating the record.
All right, but anyway, before we
getting
move on,
back to the
hold on
issue at
hold on a
hand.
second. Your view is that the issue of compliance with the statute is therefore waived, and it's not perfected for appellate purposes.
Correct. That he cannot raise the issue for the first time in appeal, which is what he is attempting to do.
Not perfected, I guess is a better way to say it, right? Is that how you'd characterize it? Not, he didn't perfect
Yeah, it was
the
not
issue.
perfected in the court below.
Right.
All right, turning to now.
Hold on.
I'm sorry.
What's the rule having to do with motions to suppress? Is it just a practice rule, or is there a
NRS 174.125, certain motions required.
174 point, what?
125.
Okay.
All motions in a criminal proceeding to suppress evidence, I'm skipping ahead here, must be made before trial.
174, I see it in your brief now, okay, good. Okay, go ahead.
Turning to page 10, the officer did testify that he followed the checklist. The checklist was admitted into evidence without objection by Mr. Mueller, so there should be a copy of that in the proceedings. That checklist sets forth all the things that were done to comply with NRS 484B.
Okay, so, assuming for the sake of argument that I get past, if I were to get past this 174.125 issue you brought up, I mean, in other words,
Yes,
assuming.
I'm assuming the court, for the sake of argument,
Let me just ask you flat out, do you think that the state complied with the roadblock statute?
yes, and the state established evidence of that by admitting into evidence the checklist that was followed that basically, essentially mirrors the statute in question. I would also just make the side note that the purpose of the statute is, that is various requirements, is very clear. It says to warn approaching motorists.
Right.
The defendant is not in the class of persons to whom that applies because the defendant did not crash into the checkpoint or run over one of the officers or get involved in a collision. The requirements of NRS 484B are set up to warn approaching motorists. They have nothing to do with the constitutionality of the checkpoint. Constitutionality of the checkpoint is established by Michigan v. Stitz, which oddly enough isn't even cited in the defense's brief, where the U.S. Supreme Court said that you can have a DUI checkpoint. I guess the court could have been a little more clear. They could have said, we mean it, we mean it, we mean it. But it is clear that constitutionally, checkpoints for DUI drivers are permissible. Mr. Mueller stated they walked out into traffic and randomly stopped cars. No, they didn't. They set up the checkpoint, and every car that came through was briefly detained pursuant to Stitz.
Okay.
So my point is, Your Honor, one, he can't raise the issue. Two, if he can raise the issue, the checklist that was admitted establishes that the checkpoint is validly set up.
Understood, thanks, Mr. Nelson. Mr. Miller, you get the last word or so.
Thank you, Your Honor. I'll draw my court's attention, and my colleague cites 174.125. There's also a provision in there, if memory serves, that says, or as soon as impractical. Now, you go to trial, and you've been in lower courts, there's 10 or 15 files. You never know which one of those cases is gonna go to trial. So what happens is if you file a motion in lower court, all they'll do is set it for the same day as the trial, and they'll wait till they have the hearing to hear it. I did raise the issue, and I'll go to the court to page 142, or page 42 of the transcript. Your Honor, I have a motion to suppress. Mr. Nance objected to the same grounds that I did, and I said the answer at the time was, Your Honor, I didn't know Officer Hobson, until Officer Hobson testified that he had no probable cause and hadn't followed the checklist for the checkpoints, I didn't have any grounds to suppress it. So it's a disingenuous argument. It is here 42, 43, and 44, this whole colloquy was held and heard by the trial court.
Right, I'll take a look at that.
It's there at 42, 43. Now, my colleague has done his best to draw you away from the thrust of this argument. The Nevada State Constitution, which says there shall be no searches and seizures. This one is particularly egregious because when they came into the checkpoint, Miss Becker's husband was in the car, and they grabbed the car and drove it around and put it in a parking lot while they're giving her the field sobriety test. So not only did they seize her, they seized her husband, and they seized her car to conduct a criminal investigation to see if a crime is occurring. That's exactly what the state constitution was written to prevent. Now, and there's no rush here, Judge. The transcript on this case is very clear. That's exactly what they did. Now, the checkpoint statute does not trump the state constitution. State constitution trumps the checkpoint statute. There's very little reported case decisions, and why we don't use our state constitution more, and we always seem to run up to the federal constitution for protection. But the state constitution, in its plain language, very clearly prohibits this.
Right.
And it's not even close.
All right, well, there's a lot to think about on
Oh, yes,
this
sir.
one, including some more review of the transcript. So I guess it's my day to continue to take things under advisement. So I'll do that on this one and give you, it'll be a couple weeks before I do a minute order on it, okay?
Your Honor, if I can, just for purposes of the court's review, I believe the elements of the checkpoint were discussed on page 10 of the transcript, as well as pages 47 and 48. 10 being Officer Hobson and 47, 48 being Officer Lang.
Okay, good enough. Okay, what else we have?
And next is gonna be page 11, and that's case number C